139th Congress. An Act to require the Secretary of Homeland Security to take into custody aliens who have been charged in the United States with theft and for other purposes. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled. Section 1, short title. This act may be cited as Laken-Riley Act. Section 2, detention of certain aliens who commit theft. Section 236C of the Immigration and Nationality Act, 8 U.S.C. 1226C, is amended. 1. In paragraph 1 in subparagraph C by striking, or B. in subparagraph D by striking the comma at the end and inserting, or, and C by inserting after subparagraph D the following. I is inadmissible under paragraph 6A, 6C, or 7 of section 212A, and II is charged with, is arrested for, is convicted of, admits having committed or admits committing acts which constitute the essential elements of any burglary, theft, larceny, shoplifting or assault of a law enforcement officer offense, or any crime that results in death or serious bodily injury to another person. 2. By redesignating paragraph 2 as paragraph 4, and 3. by inserting after paragraph 1 the following. 2. Definition for purposes of paragraph 1e the terms burglary, theft, larceny, shoplifting, assault of a law enforcement officer and serious bodily injury have the meanings given such terms in the jurisdiction in which the acts occurred. 3. Detainer. The Secretary of Homeland Security shall issue a detainer for an alien described in paragraph 1e, and if the alien is not otherwise detained by federal, state or local officials, shall effectively and expeditiously take custody of the alien. Section 3. Enforcement by the Attorney General of his state. A. Section 235B of the Immigration and Nationality Act, 8 U.S.C. 1225B, is amended. 1. By redesignating paragraph 3 as paragraph 4, and 2. by inserting after paragraph 2 the following. 3. Enforcement by the Attorney General of a state. The Attorney General of a state or other authorized state officer alleging a violation of the detention and removal requirements under paragraph 1 or 2 that harms such state or its residents shall have standing to bring an action against the Secretary of Homeland Security on behalf of such state or the residents of such state in an appropriate district court of the United States to obtain appropriate injunctive relief. The court shall advance on the docket and expedite the disposition of a civil action filed under this paragraph to the greatest extent practicable. For purposes of this paragraph, a state or its residents shall be considered to have been harmed if the state or its residents experience harm, including financial harm in excess of $100. B. Apprehension and detention of aliens. Section 236 of the Immigration and Nationality Act, 8 U.S.C. 1226, as amended by this act, is further amended. 1. In subsection E by striking or